There's the obstacles that are arbitration specific, generic, I guess
Right.
are going to exist in any arbitration case. And then there's one specific to PAGA. In any arbitration, going in, your expectation kind of needs to be that you're probably not going to get as much discovery as you might be used to in court. And you have an arbitrator who has an awful lot of power over how they administer and rule on the case. So even more so than in court, it's important to know your arbitrator, understand them, understand their preferences, way of thinking. I would say in terms of specific obstacles for pursuing PAGA claims in arbitration, there's, first of all, like in court, you need to give notice to the state before you file a PAGA claim for damages. And that ties into the whole regulatory scheme we discussed. The state has a chance to decide whether it would rather take over the case and do it. If they decide they don't want to do it or they don't respond, you can pursue the claim yourself. So you can imagine if a lawyer were representing 100 workers against a company, that's 100 PAGA notices that need to go out 65 days in advance of filing any claim for damages. The other potential obstacle with PAGA is the statute says that any PAGA settlement needs to be approved by a court. And it's going to be an open question what that means. It's highly likely that court can be interpreted to also mean arbitrator. Generally, in other situations where a statute contemplates a court doing something and didn't specifically contemplate arbitration, arbitrators are given the same authority as a court would. So there's that obstacle as well, that if you file the claim in arbitration, you need to settle it. You may need to seek approval from the arbitrator in each case for the PAGA settlement.